Good morning, everyone. On this Friday, I have a great guest today, and just continuing on with our conversation about having those hard conversations during the holidays. If you do need to have those conversations, what we're talking about today is we are talking with John McNair. He is an elder law attorney, great guy, great friend, and just talking about having these conversations before the crisis occurs. And John has been practicing law for 35 years, and his focus is on estate planning, wills, trusts, probates, and elder law, Medicaid planning, VA planning, and incapacity planning. So welcome, John, and thank you so much for your time. One thing I can say about John, I always try to recommend, we are leaders into the industry, and I like to work and interview fellow leaders in the industry and just in the senior industry. And John is one of those. You are always one. If I have a question, you are so quick to help me. You are such an advocate to seniors here in the community, and you are so well respected. So thank you so much for your time today. And we're going to start off with, why did you choose to specialize in elder care?
So a couple of reasons. First, I learned about elder care early in my life, way before I became an attorney. When I was growing up as a child, my mother was the youngest daughter of a family of, I believe, 8 children. And because of that, and because I grew up during the Depression in Mississippi, the type of long-term care that they chose for my grandmother when she started suffering from dementia was to have her live with various of her children during the year. And because my mother was the youngest daughter, she seemed to have the biggest burden, so we would have her 6 to 8 months a year for several years. And so I learned about long-term care planning very early. And then later, many years later, after my father passed away, my mother had breast cancer, which eventually became, after remission, became lung cancer, and she wanted to stay in her home till the very end. And so I would go back and forth from Texas, where I had relocated to be an attorney, and helped with her long-term care and helped find in-home caregivers for her, which was not an easy task in a small town in Arkansas. And so I learned about it, and that stayed in the back of my mind. And for years, I just did traditional estate planning. But a financial advisor started asking me to do elder law, and then I saw how that was in alignment with what I had learned as a child, and I kind of started getting interested in it and started doing more and more of it, and I've been doing it for a long time now.
Mm-hmm. Well, you do a great job. And, for me, I meet with so many families, as do you, and their goal is to stay at home. And nobody says, you know what, I have in my will that I have in my papers that when I turn 75, please put me in a nursing home. And nobody says that. Most people want to be at home if it's possible to do so. So where do you start? I know you and I talked about just having advanced directives in place. Where is the start, and what is the process? Tell me about that.
So if somebody thinks that they need to plan, I want to emphasize that people oftentimes think about only, I'm going to die. They also need to think about, I may become incapacitated. And if they do, they want to avoid the worst thing that can happen legally, and that's a guardianship, because that's expensive and time consuming and a burden for everybody. So you want to be able to put in place documents, and everybody uses the word advanced directives, but that's a specific terminology for a specific instrument, and there are a lot of other things that need to be put in place. But plan for your incapacity so that legally you won't end up in a guardianship, which typically involves financial powers of attorney. It very often might entail revocable living trust. It certainly involves medical powers of attorney, HIPAA releases, advanced directives. So there's a number of documents. If they come to me, my procedure, my process is that we will meet for a free consultation. I'll talk to them about their planning needs, and then if we figure out what they need, then I will give them a quote for that type of work, and then they can say yes or no. And if they say yes, then we start down the road of preparing their documents. Also, there are some governmental benefit programs that can help pay for particularly in-home care, but also skilled nursing care. And they may want to plan for that, and that's a whole different level of planning. So we may consider that. And again, the consultation about that planning is also on a flat fee basis, and I would give them a quote after the consultation.
Mm-hmm. Well, and so I know you have lots of stories, and there's HIPAA and privacy, but can you share just briefly, we hear about guardianships and nobody wants to be in a situation like that. Can you share an example of something that happened to someone that you may have heard of or worked with where it could have been preventable?
Well, I'm going to talk about a situation that did not involve a guardianship, and it involved one of those benefit programs that I talked about. It was a VA program, and I helped this gentleman who was a veteran qualify for a benefit to pay for long-term care. He was in assisted living, but it can pay for care in home. So when you apply, you have to disclose your financial situation because it's intended to benefit those with less assets and less income. And we disclosed everything that we thought we knew about. And he qualified for the VA benefits. So I did my job. We got it working. Well, time went on. He decided to marry a lady that he met in the assisted living home. And as those things happen, he eventually decided he needed to divorce that lady. Well, the family asked me about a divorce attorney, and so I referred them to a lady that was a really good divorce attorney in our firm. And she had to go into their finances because you have to disclose everything in a divorce as well. And so she said, "John, I think there's been a problem. He's got several $100,000 of cash value life insurance that you didn't know about when you applied for the VA." So I said, "You're right. We're going to have to disclose that." And they had to pay back a large amount of benefits. And frankly, that would have been preventable, I think, if the children had been more proactive in being willing to be a little nosy. Mm-hmm. Ask your parents about your finances. Make it a point to interject yourself a little bit in there and try to help them. And if we had known about those benefits, we could have worked around it. We could have come up with a plan, but not knowing about them, we ended up in the worst case scenario.
Well, my dad, and I use him as an example on my podcast, he was a wonderful man, terrible with finances, lived paycheck to paycheck. And he died a couple years ago. But when he was in his 60s, died in his 80s, I said, "Dad, you need to start making arrangements. You need to find a place to live that's low income for people over 65. You need to figure out, what benefits. I know that there are VA benefits out there. And so if something were to happen to you, how would your wife be cared for?" And so we had ongoing conversations, and actually one-sided, and my dad would say, "You need to butt out of it." Joe, this is my business, not yours. So as an adult child in healthcare, I did try to have that conversation. So what do you do about these people that are resistant to having those tough conversations?
Yeah, that's a very difficult one, and it's frankly not a legal question. It sometimes may be more of a counselor's question. If a senior person is willing to talk to an attorney like myself, I can point out to them all of the benefits of sharing that information with their children. But I often say to clients in all types of different situations in this planning, you can take a horse to water, but you can't necessarily make them drink. So I can point out all of the reasons that would be useful, but if they're resistant, there's not a lot that I can do about that.
And part of my goal in this podcast is just to educate people to have those hard conversations. And it should be, no, it's not an easy thing to talk about. But if you're going to talk about what school you want your kids to go to, or what college you want, or, preparing for the future, we've got to prepare for our elderly future as well. And, 10,000 people are turning 65 every day. So we're all getting older and living longer. So we just have to have those conversations. So talking about VA benefits, my dad, for example, once he did go to the veterans, it was too late. We couldn't get any care that he could have benefited from. So as far as VA benefits, tell me a little bit about the assets that you can have. Can you apply even if you're a homeowner? Tell me a little bit about VA benefits and who's eligible.
Okay, so there's a special benefit. The VA calls it pension. Out in the real world, a lot of times it's called the aid and attendance benefit. It's the same thing. It's a cash benefit, one of only two cash benefits in the VA system. The other cash benefit is one that people are aware of, and that is when they pay a veteran who has been injured during their service, and the VA calls that compensation, and that is based solely on their level of disability. It has nothing to do with the assets and income that they have. The other one, the pension, is intended to provide long-term care benefits for somebody who needs assistance with activities of daily living, bathing, dressing, feeding, toileting, transferring, and that those services can be provided in any setting, at home, in assisted living, in memory care, in skilled nursing. In 2018, they dramatically changed the rules. The income rules have basically stayed the same. If the income that you have from recurring sources like Social Security and private pension is less than the income that you're paying out for the caregiving, then you are okay on the income side. So if you have $3,500 a month of Social Security and private pension, but it's costing you $4,500 a month for in-home care or care and assisted living, then you qualify on the asset side. On the income side. On the asset side, you cannot have more than $129,000 of countable resources.
So what does that mean?
And countable resources are anything that you can use to take care of your own financial responsibilities other than exempt assets. So the exempt assets are your house, a car. It can be a car for anybody in the household. So if you're living with your adult children, it could be for you, your spouse, and your adult child and their spouse. And household goods and personal effects, funeral plan, but that's about it. Mm-hmm. So cash, stocks, bonds, retirement accounts, any investments like that would count towards a $129,000 level. So if you have less than that now, after 2018, then you would qualify. That $129,000 amount is indexed for inflation. Last year it was around $127,000, so it just depends each year what inflation is about what that number will be. If you have more than the $129,000, that's where you may want to consider coming to an attorney, because if you make gifts to try to get yourself qualified down below the $129,000 level, that creates a penalty, a period of time when you don't qualify. But we might decide to make gifts into trust for children and wait out what's called a look-back period for VA purposes. The look-back period is now 3 years after 2018, a period in which you have to report any gifts you've made. So if you make a gift and wait 4 years, you don't have to report that gift and it doesn't count against you. So for those with an estate of over $129,000 of countable resources, you might want to see an attorney. For those less than that, we don't have to worry about it.
Mm-hmm. Wow. Okay. And then what is the aid and attendance reimbursement per month?
So it depends on your status. If you are a married veteran, it will pay you a little over $2,200 a month. If you are a single veteran, it'll be a little bit over $1,800 a month. And if you are the surviving spouse of a veteran, then it will be a little over $1,200 a month. And I'm often asked the question, well, I'm a veteran, but my spouse is the one that needs the care. Is there anything for me? Well, you can't qualify for the highest level, the $2,200 a month, but you can qualify for what's called basic pension, and currently that's roughly $1,400 a month.
In addition to their Social Security check.
Correct.
That they would get. Okay, well, that's good. Well, and I know private duty in Dallas, to have somebody around the clock is about $12,000, $13,000 a month. It is very expensive to have that one-on-one care. But nursing homes and assisted livings here in Dallas are upwards of $5,000, $8,000, $9,000. I mean, we've had some clients that are in assisted livings that are paying over $10,000 a month for care. So it's, I try to explain that our product is people, and we have insurance, we have bonding, we do the vetting. It's a lot more expensive to have a private duty agency than people realize. There is a lot done on the back end to assure quality care. So what steps should be taken, John, to prepare someone for possible future incapacity? So say I'm just going to share, I'm 58. Tell me if I haven't done anything. I've never met with an estate attorney. I've never made any decisions. I haven't I don't even have a will. Tell me the steps, and what would you recommend for me as a healthy woman? What would you recommend for me?
So first off, I would sit down and do some accounting, figure out what you own and how much it's worth, because anybody that's going to help you with planning needs to know what they're planning with, and that's your assets. That's half of the problem. Your medical issues is the other half, but planning for dealing with your assets is one of the issues, and we have to figure out what you own and how it's titled, because there are a lot of different types of assets and they have lots of different ways to be titled. You might have real estate that might be in your name or your name and your spouse. You might have retirement accounts that can only be in your name and can only go by beneficiary designation. They can't be owned by another trust. You may have accounts that are joint tenants with right of survivorship to somebody, and that is going to be a contract which overrides any trust that we create or any will that you write. So we need to know how it's owned, how much it's worth. We need to know a lot about your assets. Once we understand your assets, then we can formulate a plan to figure out how to deal with those assets and make sure that if you're incapacitated, we have them structured in the right way. The second thing is to start thinking about, if I'm incapacitated, who's going to help me? That may be the hardest part of this process. Start thinking about, well, it's going to be my spouse. That's obvious. Well, okay, that's fine. But what about if your spouse is not around? We need to have layers. We need to have backups. We need to have contingent persons that are named as your backup agents for financial powers of attorney, backup agents for medical powers of attorney, backup trustees if you use a revocable trust, backup executors so on your will. So as many names as you can put in there. And that's sometimes not easy for people because they may have a small family, or there may be unusual factors in their family dynamics where there's not a lot of people they feel comfortable appointing. But sitting down and thinking about that and coming up with a plan about, maybe here's the worst of my options and here's the best of my options, and I'll take the best of my worst options. I mean, there may not be a perfect solution, but start thinking about who you're going to appoint to do these things for you.
And, you know, just doing home care and working with seniors, and I have for a long time, as have you, I have found people that have not made those decisions. There's usually one adult child that is, you know, carrying the burden. And you could alleviate so much stress. And I'll even say to families of the one adult child, you know, your sister needs a break. You know, your sister, but she doesn't work, and, you know, she's always been mom's favorite. I hear all kinds of things, but just doing these things are so important to make things so much less stressful when that time comes. So is estate planning just for millionaires?
No, estate planning is definitely not just for millionaires. We've talked about issues that are affecting people who need long-term care, and in fact, the planning for those, particularly for those long-term care governmental benefits, is people who are decidedly not millionaires. Millionaires may have enough money, they'll decide to self-finance their long-term care, so it's not an issue for them. And estate taxes are an issue almost for no one these days. You have to have an estate of $11 million for one person, or $22 million for a married couple, to even worry about estate taxes. So most people don't need to worry about estate taxes. They need to worry about, am I prepared for incapacity? And am I giving my property to my family in the best way possible? I could potentially create trust, for example, after I die, for my family that would protect the property from their creditors and their divorces. So that's a benefit that you can provide to them that might be useful and might be something you'd like to do. But unless you put that in place, unless you sit down and do the hard work of doing that planning, it's not going to happen.
And I'm one of those. Before I got into healthcare, I really thought the estate planner was the estate attorney was someone that just dealt with the very wealthy. So this has been great information. So what would you say is the ideal age to contact an elder law attorney?
Well, a lot of times I'm being contacted by adult children who are in their 50s and 60s, and unfortunately that's probably not the ideal. I would say most people still feel confident that they are in control of their self and their finances into their 70s, but may recognize that at that point I'm soon to be at a place where that may not be the case. So I would say certainly in your 70s. Maybe a lot of people in their 60s don't feel like they need to worry about that, but starting to think about it in your early 70s and certainly in your mid to late 70s, I would seriously consider planning, because oftentimes you're still healthy, you still have your faculties about you, and that's the best time to plan, because you can participate, and it's not your family trying to scramble to do some planning when you may not be capable of helping as much as you possibly could.
And I know there are a lot of attorneys that say they do estate planning, and I've seen, some that do advertisements, they do divorce, they do criminal, estate, bankruptcy, like they squash it all together. So how can you tell whether an attorney has the experience needed to handle the complexities of Medicaid planning and other elder law matters?
Okay, well, there's a couple of credentials that you may look for. For example, the state bar has a program where you can become a specialist in particular areas. You can become, quote, board certified in criminal law, board certified in personal injury law, board certified in real estate law. You can also be board certified in estate planning and probate, and I've had that designation for many years. There's also an organization called the National Elder Law Foundation, which is affiliated with the National Academy of Elder Law Attorneys, which oversees a program where you can become a certified elder law attorney. And I've also gotten that designation. And for both the state program and the National Elder Law Foundation program, you have to have had many years of experience and prove that you have experience in those particular specialties, and that you are really aware of the issues, because you have to pass a test for both of them. A really, really hard test, I might add. So looking for somebody with those credentials might be a really good way to ensure that you're working with somebody that knows what they're doing
and does the right thing. And then one last question. I have a lot of people that ask me about long-term care insurance. And we have had clients that, you have to cash in on those long-term care policies. You have to be able to show that you have the need for those activities of daily living. Do you need help with feeding or bathing? And I've got some clients that truly need our care, but they're not qualifying for the services. Or the insurance company, it's taking so long for them to be reimbursed. It seems like it's harder for those to cash in on those policies. So what are your thoughts on the long-term care policies for someone, let's say, in their 70s, early 70s, that's healthy? Would you recommend that they get a long-term care policy?
I don't know that I would say that I would recommend that they get one. I think that I would more probably say that I would recommend that they talk to a financial advisor and learn all that they can about the product and make their own determination. I think there are many advantages to it. Obviously, I won't say obviously, but a lot of times if you pay more for something, you get a better quality product. Mm-hmm. If you pay less, sometimes you don't have as quality a product. And of course, the companies make their money by taking in premiums. They don't make their money by paying claims. So
Right.
They're going to be really careful about paying out claims. And that's all of the, what I'll call back-end underwriting that's being done when they're slow to process the claims, et cetera. But I do think that they are useful to consider. Mm-hmm. And I will say in years past, traditional long-term care policies, I know a lot of people think they're very expensive, and I think they probably are. And they were always worried about whether they would ever use them, and all of those premiums were for naught. The industry has, I believe, innovated to a certain extent, and now you can purchase financial products like annuities or life insurance policies that have a long-term care rider. So at least you know you're going to have a product that will benefit your family, even if you ultimately don't use the long-term care part of it. But again, I'm not an expert enough to know that everybody absolutely needs long-term care. I would say it's something you should consider reviewing with your financial advisor.
Well, and just the reimbursement for, sometimes we have people that have a reimbursement of $150 a day, or they can get a nurse visit every day. And then we have some that if they're on hospice, they will allow a client to cash in on their long-term care policy because they are on hospice early. So it is important to do the necessary homework, because there are some wonderful policies out there, and there are not so wonderful. Anyway, but it's just lots of conversation. We could continue on and talk on about helping others. And John, thank you for your help and your time. And I just can't say enough about the service that you provide in the Dallas-Fort Worth community. You do a wonderful job. And if somebody needs to reach you or has a question, where would be the best way to reach you, John?
So you can call me. You want me to
Yes,
give out the
that'd be
phone
great.
number? 469-210-8371.
Okay.
Or you can email me at jmcnair@mcnair-dallaslaw.com. I have a website, www.mcnair-dallaslaw.com, so you can check out my website before you decide whether to contact me or not.
Great. Thank you so much, and I hope you have a wonderful weekend.
Thank you for having me.
Thank you. It's been great. I appreciate it. Appreciate your time.